class, and welcome back for another Flex Time review. In today's lesson, we will introduce the clinical psychology unit by talking about the insanity defense. As per usual, if you would like to follow along with the lesson, there is a link to a worksheet in the description box below. So, let's get started.
Aurora Theater shooting suspect James Holmes will be moving to the state mental hospital. Holmes in court this morning changing his plea to not guilty by reason of insanity.
Yeah, a big surprise there, Vinny. That trial hitting a temporary roadblock this morning after questions about Mr. Spooner's mental state came into play. Now, this all started when the judge asked if Spooner planned to testify. His attorney said no, but the 76-year-old insisted he wanted to talk.
Hi, everyone. The Williamson County man accused of killing his father back in April had his day in court. Daniel Cantrell's fate was decided in less than an hour, and he most likely will never see a prison cell.
Owen began with the only defense he could. If he wanted to save his client's life, he would have to try and prove Brandon Wilson was insane.
A riveting trial taking place in Atlanta. A young father gunned down as he dropped his 2-year-old son off in the morning at preschool. The victim, 36-year-old Rusty Snyderman, a Harvard Business School grad and father of 2 who married his college sweetheart. And the man on trial for his murder is pleading insanity, claiming an angel who looked like Olivia Newton-John told him to do it. We examine his unusual defense tonight for our series, Crime and Punishment.
Whether it be from the news, a movie, or a TV show, chances are you have heard of the insanity defense before. But do we really know what it is? Insanity is actually going to be a legal term used in courts when an individual being tried for a crime is deemed not responsible due to suffering from a mental illness of such a severe nature that the individual cannot distinguish fantasy from reality. Being a legal term, individuals working in the mental health field do not use it, meaning a psychiatrist will never diagnose a client as insane. However, mental health workers, specifically those who are members of the American Psychiatric Association, strongly support the defense, stating that the insanity defense has always been grounded in the belief that there are defendants whose mental condition are so impaired at the time of the crime that it would be unfair to punish them for their actions. And this is not going to be a new concept. Roots of the insanity defense can be traced back to England in 1843 when Daniel Monaghan was under the paranoid delusion that the Prime Minister of England, Sir Robert Peel, was trying to kill him. In an assassination plot, Monaghan attempted to shoot Sir Peel but missed and struck the Prime Minister's secretary, who died as a result of the gunshot. Monaghan was then put on trial for murder, where the jury ended up finding him not guilty by reason of insanity. Due to the public outcry of the controversial court hearing, the British House of Lords developed a test that proves insanity that remains relevant today, being the most common used insanity defense in U.S. courts. The defense is going to be cognitive and focuses on the defendant's awareness instead of their ability to control conduct. This defense is going to include 2 elements. First, the defendant must be suffering from some mental defect at the time the criminal act was committed. And second, as a result of the mental defect, the individual did not know the nature and quality of the crime and or the fact that the act was wrong. Now, before we get into some examples of real-life trials where the insanity defense was used, I think it is important to clear up a few misconceptions that some people may have about this type of court ruling. Insanity defense trials can draw up some controversy, especially during a high-profile case. Some people are going to believe that it's unfair that someone who clearly committed a crime could be found not guilty. And a lot of this comes from the fact that not everyone fully understands how the insanity defense works. I already touched base on an important aspect earlier, stating how psychiatrists or other mental health workers do not decide if a person is insane. They can, however, be used as an expert witness who can offer a testimony on behalf of the defendant in order for the court to decide if the defendant is legally insane. While insanity defense cases get a lot of media attention, they are actually incredibly rare. A 1991 study found that the insanity defense is used in less than 1% of court cases. And out of all these cases, the defense is only successful about a quarter of the time. A successful insanity defense does not translate into freedom back into society. An American Psychiatric Association study found that those who are acquitted by reason of insanity, on average, spend longer periods of time institutionalized than those in prison who were found guilty of similar crimes. So, in summary, the defense is not a get-out-of-jail-free card, and with how rare they are, of course they get a lot of media attention. Now on to some case examples. I am sure many of you are familiar with the case of Jeffrey Dahmer, a serial killer who from 1978 to 1991 murdered 17 individuals. Among other heinous acts that Dahmer committed, we have cannibalism and the preservation of body parts. Dahmer was diagnosed with borderline and schizotypal personality disorder, but Dahmer was considered legally sane at his trial and was convicted on 15 of the 16 murders and was sentenced to 15 life terms on February 15, 1992. Another case where the insanity defense was used was in 2013 when a 17-year-old Iowan teen killed his 5-year-old brother while playing with him outside.
He admitted killing his 5-year-old foster brother in Logan, Iowa, but the bizarre behavior of the 18-year-old in court was just too much for a judge to overlook.
His attorney's reason for using the insanity defense? The teen told a psychiatrist that he was trapped in a fantasy world when committing the act, testifying that he believed his brother to be a goblin commander that he needed to kill. The expert witness for the defense testified that the teen's lack of emotion when he described the attack on his brother was evidence that he was in a psychotic state when the crime was committed, and as a result, the teen was given the sentence of not guilty by reason of insanity. Now, with the information provided in both of these scenarios, it appears that we are dealing with individuals with some form of mental defect. But how come one was given a not guilty verdict while the other a guilty verdict? Well, to answer that question, we have to go back to the legal elements of the Manhattan defense, which state that to be acquitted by reason of insanity, the defendant must show evidence of a defect of the mind as well as lack of awareness of any wrongdoing. In regards to the Dahmer case, it was evident that Dahmer has a defect of the mind with his personality disorders diagnosis. However, the defense was unable to convince the jury that Dahmer was unable to control himself at the time of the murders, leading to the guilty verdict. While for the court case with our Iowa teen, the expert witness testimony was able to convince the jury that the teen was suffering from some form of mental defect, as well as feeling no remorse for his actions, leading to an appropriate Manhattan defense. So, there is our lesson on the insanity defense. It is important to remember that this is not some legal loophole where a person is getting away with some illegal crime, but an attempted form of rehabilitation to those who are suffering from extreme mental issues. If you enjoyed the video, please feel free to like and subscribe. It is always appreciated and will keep you posted on when I post new videos, such as our next lesson, which will further fight to end the negative stigma on mental disorders as we discuss mental illnesses and violence. I will see you then.